That's what we're here for. Keep people happy.
The only problem is now I'm running around. Hey, I'm all steamy.
Like, why do you need to work out when you just like
I
run up
need
and
to
down
walk
the,
into a walk-in freezer.
Yeah. Mr. Chairman, how you doing?
Doing better than I deserve.
Well, that's not easy.
Okay. Good morning. Pray with me, please. Heavenly Father, here we are again asking you to forgive us of our sins, to say thank you for the blessing of the day, to say thank you for all our blessings. Let us do things that please you, and when we don't please you, please forgive us. Have mercy on us. Lay your hand on us. Let us have a good day. Lead, guide, and direct us. In Jesus' name I pray. Amen. Good morning again. On the wall you will have senators, if I could get my group to show up on time, this would go a lot quicker. But things will be a little bit different today. We're going to hear the senators you have in your book. I think all of the bills that they will represent except for one. And then we'll have it in for our next meeting. Again, all we're going to do is hear their bills. We'll have another rules meeting later on this morning where we will start setting the calendar. It's a timing issue. I do not want to do what we do every 40th day. It gripes me that we do that. But we're going to hear their bills. We'll have another meeting later on this morning to set the calendar for today and for Friday. Any questions? Who's first? My senator, Mr. Bethel.
Thank you, Mr. Chairman and members of the committee. I come before you with three bills. The first is about halfway down the page on modified open. It's Senate Bill 290. This really is just to preserve the status quo in Georgia as it relates to attorneys who close real estate transactions. It makes clear that they don't have to have an insurance license. They've never had to have one in the past. There is some ambiguity in the law, and this clarifies it. Further down that page, Senate Bill 347. This is an ongoing effort to improve Georgia's captive insurance laws. This is the agency captive piece that allows the insurance agencies in your communities to provide reinsurance for policies that they write. It comes to us with the recommendation of the department. And then on modified structure, the next page, the third from the top, Senate Bill 193. This basically allows our automatic aggravation statute that relates to domestic violence operate in the way that it was intended. There are two identified loopholes that allow someone to have sort of more than one bite at the apple before the automatic aggravator kicks in. This closes both of those loopholes.
Do I have any questions from the committee? No questions. Thank you, Mr. Bethel.
Thank you, Mr. Chairman.
Mr. Jones.
Thank you, Mr. Chairman. I rise today to ask for or ask to be heard on Senate Bill 309, which is actually a duplicate bill of House Bill 870 that Representative Strickland carried over in the House, and it passed through Education Committee unanimously, as well as the same bill 309 passed through our Education Committee unanimously. We move a little slower on the Senate side, so that's why we're having to come over here and ask y'all to show us how it's done.
That is an understatement.
Yes, sir. Yes, sir. So it's the crossover bill allowing schools that like to participate in athletics with schools that are not affiliated with the Georgia High School Association. This bill allows them to be able to participate against one another, and also if a young athlete is expressing themselves in a religious fashion, it asks for them not to be discriminated against.
And you got another one?
No, sir.
Okay. No questions? No questions. Thank you.
Thank you, Mr. Chairman.
Mr. Thompson.
Thank you, Mr. Chairman, members of the committee. I bring before you Senate Bill 263. We had a local law enforcement officer, a chief of police in Bartow County, when he retired, wanted to retain his service revolver and his badge, was not permitted as you are on a state level because the local attorney, city attorney said, we're not permitted to do that. This is simply permissive, said the state will not weigh in this. It's a local bill, basically allow them to have local control. If they want to be able to allow them to keep the weapon and the badge, they can.
No questions. Thank you.
Thank you, Mr. Chairman.
Mr. Hardman.
Yes, sir. Mr. Chairman, committee members, thank you. I bring before you Senate Bill 137. It's a simple bill in that it modifies the current statute where what is called a valued policy. Currently, it only allows for a named individual, and what this allows us to add is any legal entity, LLC or corporation, which when the statute had been formed did not exist. So it's just a correction from the standpoint of the statute, allowing LLCs and corporations to participate in the statute.
No question. A question to my committee. Have y'all been to Rue's over there yet? Do they let y'all off this easy? How do you get a bill on the first page over there?
I'll go find out.
Richard gave the best one. He's a freshman. He don't know. Thank you.
Thanks, sir.
Mr. Burke.
Thank you, Mr. Chairman, members of the committee. I have bring before you fourth one down, a modified open on the front page, Senate Bill 158, which allows the insurance commissioner to register rental health networks. And the second bill is eighth one down, Senate Bill 273, that decreases the regulation for biologic manufacturers and is a good economic development bill for our biotech world.
Any questions for Mr. Burke? No questions. Thank you.
Thank you, Chairman.
Mr. Albers.
Thank you, Mr. Chairman. Members of the committee, good morning. Under modified open rule, number 9 and number 10 on your list is Senate Bill 274 and 277. 277 is a population repeal to allow our counties that are larger than 200,000 to set their own budget date. Worked closely with Chairman Willard on that bill. And then Senate Bill 277 is protecting Georgia Small Business Act to prevent from federal overreach to protect all of our wonderful franchisor and franchisee businesses here in Georgia.
Questions? Mr. Willard.
Good morning, Senator. On your 274, that's the same bill that passed this House last year.
Yes,
correct?
sir. I am. You passed that. Unfortunately, for some reason, it didn't get made through the Senate, so I'm here to help out my fellow delegation member.
The Senate would get it hopefully through the House. It only applies to Fulton County, although the population changes now really bring in 2 more counties, Cobb and Gwinnett.
Absolutely, and it's my honor to help out in getting that passed.
Thank you.
Ms. Smith.
Thank you, Mr. Chairman, and thank you for your bill. At one point in the past, we were very leery of defining our legislation with population numbers. Has that been vetted through legal counsel as using population numbers?
Yes, that's a great question. In fact, this removes that, so we are not allowed to do population bills, and this is a great one where we're just taking stuff out of the code. Thank you for your question.
Mr. Peake.
Senator Albers, on 277, the franchisee bill, have you had discussion with the hospitality industry? Obviously, that has a significant amount of franchisees.
That's an excellent question. In fact, Senate Bill 277 has got support from the Georgia and U.S. Franchise Association, the Georgia Restaurant Association, Hotel Association, NFIB, Chamber of Commerce, everyone to protect our 330,000 employees who work, as well as all those entrepreneurs, small business owners like yourself.
Okay, thank you very much.
Mr. Williams.
Thank you, Mr. Chairman. First, I was afraid there was going to be insurance bills this morning, so I was glad to see yours. On 277, very briefly, can you tell us what the problem is that that made this necessary?
Certainly. Back in August of last year, the NLRB, in their infinite wisdom from Washington, decided to change the rules to say that franchisee and franchisors' employees would now be basically co-employed with each other, which would really remove a model that has been tremendously successful across America, but very much so in Georgia, to allow those small businesses to start, allow entrepreneurs to hire folks locally. And this will allow us to maintain the status quo and continue to let that industry thrive here in Georgia.
No more questions, thank you.
Thank you, sir.
Mr. Hill.
Morning, Mr. Chairman.
Sir. Seventh bill down, Mr. Chairman, on a modified open rule is Senate Bill 243, and I have Legislative Council with me here this morning to discuss a problem that Legislative Council has had. Originally, the councils in the Legislative Council's office were part of the judicial retirement system when it was created in 1998. In 2005, I believe it was, they were removed for reasons that had nothing to do with them. There are 3 members of the 8 councils now who are members of the judicial retirement system. The problem that we're trying to solve is for all of us who have legislation drafted, it's important sometimes to talk to someone who's been there a while. And one of the problems that we're having is finding, not to cast aspersions on anybody who's there now, but what we want to do is keep them long term so that they have some corporate memory and have some continuity so that when we walk in to discuss an issue, they can tell us the history as well. What's happening is what we'd like to hire for that agency is mid-career lawyers who have a good bit of experience, who aren't just coming out of law school, who have some real life experience that they bring to the job. But we're unable to keep them. The pay for attorneys fluctuates greatly out in the marketplace, and with that experience, they're in demand. So we believe by moving those positions back into the judicial retirement system, which is over 100% funded, that we would strike a blow for keeping long-term our legislative council. And I have him with me here. He would be happy to answer any questions that I can't answer, Mr. Chairman.
Mr. Ramsey.
Wasn't this the case back? I'm right here, Mr.
Oh, I'm
Chair.
sorry.
That's okay. But didn't Legislative Council go into this system prior to, I think, the mid-2000s, and then they were removed from
my understanding,
retirement system?
And Wayne can correct me if I'm wrong. My understanding is they were in it when it was created. They were put in it when it was created in 1998, and all positions in Legislative Council were members of JRS until 2005. When they were taken out along with all others who were not actually judges.
And what was the impetus for that?
I don't know, other than it had nothing to do with them. It was more of a decision of some other folks trying to get into the system, and they just took everybody out. It's what I'm told.
Thank you.
Mr. Fleming.
Thank you, Mr. Chairman. I was also trying to think back as to why this happened, and I'm going to go see if I can get my memory straight, but I recall we tried to do a lot of cleanup. Can you hear me? Yeah. We tried to do a lot of cleanup of problems in the retirement systems back around that time period, and I'm not sure if this was inadvertent or just taking everybody out of the system that wasn't a judge, but I can tell you that I appreciate the chairman bringing this bill, and isn't it true that as you try to recruit the best and brightest for us to write these bills for us, that nothing can be more discouraging than you get through the process and realize there's a potential drafting mistake. And if we can use this judicial retirement system, which is very good at drawing the best and the brightest into a judgeship, that it would probably allow us to recruit the best and brightest to bring into Legislative Council going forward.
When I came in the 1990s, Mr. Chairman, early 1990s, when I went up those steps and sat down with an attorney in Legislative Council, I was speaking to an expert in the field. Yeah, we had experts in tax policy, we had experts in state government. We had folks who could not only tell you what the present situation is, they could date back to earlier Attorney General's opinions and give you the background on it. That was extremely valuable. Today, it's not so much, and so the ones we have today, we want to keep them long-term, so when they gain this knowledge, it'll be there for us as the time goes by.
Mr. Willard.
Good morning, Senator.
Good morning, Mr. Chairman.
They are currently under a plan. It's just not the judicial retirement
They're under
plan.
ERS currently.
And tell me, what is the difference as far as vesting? As I recall from judicial plan, after 10 years service, you're vested as opposed
to draw, they have to be age 60 to begin with. They have to they have to have 16 years of service for full retirement. Those two factors alone indicate a person who came into the field in mid-career, if you think about it.
Yeah.
They also contribute a good bit more than employees do to ERS. If you're married, you contribute 10% of your salary into the JRS.
And one last thing, it sounds to me, and I know from serving on the legislative committee, we're not paying these people enough money. And I suggest we look at paying them better salaries as a way of maintaining them in their positions and attracting quality people to those positions. That's
certainly true. I will say this, though, the same quality that seems to draw mid-career lawyers who want to be judges is the same feature that would draw people in mid-career into the Legislative Council as well. It's an idea towards serving 16 years and getting a retirement and being there for the remainder of their career. So I think the two actually complement each other.
Madam Pro Tem.
I did also want to ask if you had considered, instead of adding to our retirement liability, which I think that was part of the impetus, I looked into it back in '05, was to try to begin, when Republicans took control of the House, the Senate, the governorship, to try to begin reducing our liability for retirement. Did you look at, as Representative Willard said, significantly increasing the salaries, which would be far cheaper than significantly increasing the defined benefits?
Well, you know, pay is a fleeting thing, I would suggest to you. And we did give them an extra increase last year for those persons. I would just say this. I believe, of course, as I said, the JRS is 100% funded or more. So it's actually 0.039 or something. 0.09. It's less than 1% change in the retirement status. So if it was a fund that was where the ERS is at 73%, then I guess you could make that argument. But I would suggest that pay is always in a marketplace where lawyers are a commodity. I would suggest that pay is it may not even be the most important thing to keeping people in a career. But by the mid-career, which is where you're aiming at, lawyers are the point that they are looking for retirement and they're looking to utilize their experience. So, yes, in one respect, as a conservative, I see your point. In this isolated case, though, I really believe this benefit would serve our body very well.
One further question, and I'm open. When I do the math, a 10% contribution for 10 years at $100,000 would be $100,000 that person had contributed. But after vesting at 10 years and receiving a third of their salary, should they leave them?
They won't receive anything until age 60.
Right, but at age,
unless they're on disability,
mid-career at age 45. In 3 years, they would have received all of the money they would have at age 63 had contributed. And but I mean, I'm open. I see your point that we need longevity. I just wondered if a significant increase in salary might do the same.
You know, we're all fighting that battle now. We're fighting it in the budget offices. We're fighting it in state employees. We're fighting it in state troopers. We're fighting it everywhere where you've got competing market forces drawing people back into. And, you know, I just don't know that money will do it. I don't know. I'm not an attorney, and many of you are, and maybe you can, you know, I'd be interested in your opinion, but we believe that this benefit, which returns it to the way it originally was, they were originally members of this retirement system, is one benefit we could give that we think has value. Maybe that's not the only thing we could do, but it's certainly one important thing.
I appreciate that. Thank you.
Thank you.
Mr. Golick.
Thank you, Mr. Chairman. Chairman, just for clarification, the benefit that the Pro Tem referred to is not at 10 years, is at 16 years minimum with age 60. They vest in 10 years, but that's not at a full benefit, just to make sure it's clear. Yeah, I think that's correct. Well, it's based on the Superior Court judge's base salary, and then it increases from there depending. It maxes out at 24 years. Excuse me, it maxes out at
16,
at 75% with 24 years experience, and they can't go beyond that. But to the chairman's point before, and actually to go back, that was the time that, if you recall, when the new majority took over, that we were looking at, the previous administration was looking at the slow transition from defined benefit retirement plans to defined contributions. And of course, with the various plans out there and the different formulas, that's like moving a cruise ship. But admittedly, but to the chairman's point, as a retention tool, I would just submit to you, I don't think you ever, with legal salaries, you're never going to get there just on salary. It's all the retention tool, and that's what we're talking about as a retention tool, is going to be on the retirement benefit. And that's not really unlike any other, so-called contract we have with other state employees, that the implicit agreement is, yes, it's going to be a lower amount for X period of time, but then the payoff comes later in the defined benefit. There are various viewpoints on that, I get it. But in terms of this type of talent and this type of institutional knowledge that has, I would submit to you, greater value to the state, the retention tool that the chairman points to on the retirement end is well worth it. I just don't think we ever can physically get there on salary. But I appreciate the question, though.
And is
the
it
comment.
that we can't get there on salary because this is so much more valuable?
I don't think from a market standpoint you're ever going to do enough on the salary end, which I'll call the front end, to be able to get talent, let alone retain it, as opposed to what the offer is on a defined benefit later on in retirement. That's the attraction to retaining talent.
Thank you.
Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. Chairman Hill. Would you agree that, as I'm unpacking this, I feel like Legislative Council is a fantastic resource for us as a citizen legislature. The fact that not just for drafting bills, but the fact that I can call them out of session on complicated legal issues and have somebody that is an expert, I see it as a tremendous resource for the legislative branch as a whole. I feel like in the scheme of things, we're a relatively weak legislature because we're not full-time. We've got outside jobs. We can't afford to pay staff to do this. I feel like this is a very strong resource for the legislature as a branch.
Exactly.
And I appreciate you bringing this, because I feel like the resource and the experience that I've got somebody at Ledge Council that has experience that really nobody downtown Atlanta has in certain areas of law. And I just, to me, even more than drafting bills, that's the importance of this.
Absolutely. No more questions. Thank you.
Thank you, Mr. Chairman. Appreciate your knowledge.
Mr. Martin.
Thank you, Mr. Chairman, committee members. I bring to you Senate Bill 302, which is 13 down, number 13, about 2/3 of the way down on the front page under modified open rule. SB 302 provides a clear framework for health insurance companies as they put together their provider directories. It sets clear regulation on what should be there, how often it should be updated, and sets a timetable for there to be an audit done to make sure that these are currently correct, and then so that they remain correct going forward. I ask for your consideration.
No questions. Thank you.
Thank you.
Mr. Gooch.
Good morning.
Good morning.
Back of the page, second bill from the bottom, SB 316 is a good bill. Substitute came from your House Regulated Industries Committee. The original bill basically eliminated the daily allowance for bingo, kept the weekly allowance as $3,000, but we did add in section 1 that the numbers shall be chosen by a natural person. Doesn't allow for electronics to be used in that process.
Mr. Fleming.
Thank you, Senator. I appreciate you coming here this morning. Now, we're changing the amount that a person can be paid per day, but this bill, is that what we're doing?
We're basically striking in lines, if you have the bill in front of you, lines 24, it says $1,500 in cash or gifts of equivalent value during any calendar day, $3,000 in cash of equal value for any calendar week. So right now, current law allows you to have up to $3,000 a week in gifts and prizes, but only $1,500 in any calendar day. This strikes the line pertaining to the calendar day, keeps the $3,000 weekly allowance. So you could essentially have one game a week and you could give the entire $3,000 in that one day instead of having to break it into 2 different days. This is only used in nonprofits around our state. A lot of your charities are using these bingo games for their local fundraising events, for their school scholarships and other attempts.
Thank you, Senator. And my last question was, I know that through the years here, we've had several of these bills come through that tinker with the bingo code sections, and unfortunately, sometimes in the past, it's affected other things like video gaming and whatnot unintentionally.
Mm-hmm.
Has the District Attorneys Association worked with you on this? You got any comment from them about what they think this does or the unintended consequences could be?
I believe Chairman Powell may be a better person to listen to on that question, but I think it's fine with them.
They're endorsing this bill?
As far as I know, yes, they brought the substitute through the committee and asked for the language should be put in it. But
thank you, sir.
I don't want to speak for the chairman.
Mr. Powell.
Thank you, Mr. Chairman. Is it not true that in the Regulated Industries Committee that we amended this bill so as to prohibit these video type machines from being able to participate in bingo?
That's correct.
No more questions. Thank you. I'm sorry, Mr. Ramsey.
Thank you, sir. The language, it wasn't in the bill originally on lines 32 dealing with the electronic devices and limiting bingo to numbers chosen by a natural person. I wasn't in the committee, didn't hear the discussion. What was the impetus for that language? Did it come from the COAM folks?
The committee chose to insert that substitute, and I agreed with it and I supported it. So I think it's just to prevent.
Was there any discussion around what situation is happening out there using devices to pull bingo numbers that we've got to exclude that from?
Apparently there's a problem in Alabama where they're having trouble with these electronic type games, and they're trying to prohibit those problems from being here in Georgia. So
okay.
The chairman, again, Chairman Powell may be a better.
Mr. Powell.
Yes, sir, to my friend, Mr. Ramsey. The reason we put this in is that sometimes, as you know, with these electronic machines, they can try to figure out how to get in or get the nose under the tent. This happened over in Alabama, so what we've done is we've taken a preemptive move to say that those electronic video type machines, that they can't be used for bingo.
No more questions, thank you.
Could I ask for one more piece of legislation?
Why, sure.
Thank you. Senate Resolution 876 was passed out of your Special Rules Committee yesterday, and it's not, you can't see it on the bottom of the sheet, but it's a broadband study committee, a joint broadband study committee for the House and the Senate to spend some time over the summer and fall. We have a lot of issues all over the state with rural broadband needs and issues. Bandwidth is an issue. As you all know, economic development is critical for our state, and especially in the rural areas, and without broadband to service those areas, we're limited in what we can try to do in that industry expansion. So I would appreciate your support on that as well.
No questions, thank you.
Thank you.
Ms. Underman.
Good morning, Mr. Chairman. It's a pleasure to be here and be before the Rules Committee for the second year of our term. I bring before you on the second page the last 4 bills. 3 bills have passed through the Senate. Senate Bill 278, Senate Bill 305, and Senate Bill 308. Senate Bill 278 is under modified structure rule. This is an issue that we have been working on for about 6 years now in the General Assembly. This elevates the crimes of pimping and pandering and keeping a place of prostitution. It increases the penalty from a high and aggravated misdemeanor to a felony conviction upon the second stance of being convicted. Senate Bill 305, and that's for folks that are 18 years and older. Senate Bill 305 is the post bill, physician's orders for life-sustaining treatment. As you will recall, last year we passed a very comprehensive post bill. This is a cleanup because we inadvertently left out the language that I had actually promised some folks with the Georgia Right to Life, that if the post form is changed, that it would have to come back for oversight from the General Assembly. And that language is included. It passed without any opposition. And the last bill under the structured rule is Senate Bill 308, Positive Alternatives for Pregnancy and Parenting Grant Programs. This particular bill involves the Pregnancy Resource Centers. I appreciate Chairman Cooper. We had, I think, about an hour and a half long meeting the other day on this particular bill. It sets up a grant program for PRCs. We put the money into the budget for that. And as you know, the Pregnancy Resource Centers offer counseling, they offer pregnancy testing, and they offer ultrasounds free at no cost, unlike other locations. I'll be glad to answer any questions on any of those three bills.
No questions. Thank you.
Thank you very much. I appreciate it.
Mr. Tippins.
Thank you, Mr. Chairman, members of the committee. I bring you Senate Bill 191, 6 down from the top on the first sheet. Senate Bill 191 provides for a uniform utility locate law, call before you dig law in the state of Georgia as it has been administered. It's under the direct supervision and control of the Public Service Commission, and they have done an admirable job in the past in overseeing this and having uniform locate law throughout the state. This law also provides for the window that a utility locate would be open for 21 days to 30 days, which would result in a considerable savings to those utilities that may have to remark on ongoing projects. This is a law sheet from 2015. There were some issues raised last year. GMA had some issues with it. We've worked through the summer and fall. I believe all of those concerns have been settled. The utility companies, the construction industry, GMA is all right. ACCG is not in opposition to it, and I believe this is a good bill that helps everyone involved, the utilities, the contractors, all the way around, and it provides for the safety and uniform safety in the state of Georgia.
Mr. Fleming.
Thank you, Mr. Chairman. Senator, right here. So I was looking through the bill, and in section 1, we're changing a 21-day period to a 30-day period. How does that work? What are we doing there?
Well, when you call in the one call before you dig, they come out, and all the utilities come out and ascertain whether they have utilities in the area of construction that is described in the initial request. They come out and they locate the utilities. That locate is good for currently 21 days, and at that point, whoever has requested the locate would have to call for a remark. That just makes that 21-day period go to 30 days. Most of the time, these markings will survive 30 days, and it used to be 14 days, and it has worked well to go to 21 days. It's not a problem. If the marks are obliterated, you can call and ask them to come out and do a remark. But there's no point in somebody having to come out every 14 or 21 days when 30 days is sufficient. It just cuts down on the manpower that's required to maintain the markings.
And if I could, in section 2, Senator, we're preempting there any local ordinances or rules that deal with this marking of lines?
Well, the problem with that is if you had every county and every municipality that had a different set of locate rules in the state, you'd have such a mishmash. I'm not sure anybody would know who to call. This needs to be uniform. It's not like this is easy. I can tell you, if you cut a utility in the state of Georgia and you're negligent, the first letter you get from Public Service Commission mentions a $10,000 fine unless you can explain why you cut that. So this is not child's play. It is very stringent under PSC, and they have done a great job in enforcing this, and I believe we do need a uniform law throughout the state.
Thank you.
No more questions. Thank you.
Thank you, sir.
Mr. Harper.
Good morning, Mr. Chairman. As always, it is such a privilege to be in front of such an esteemed group of members of the House. And since you've already got all of your questions out of the way, I look forward to a very brief description of Senate Bill 279.
What part of brief didn't you understand?
It's 11th down on the front page under modified open. This bill, what this bill does is deals with the post council. And on post council, every member of state law enforcement is represented except for two agencies. Those agencies are DNR and the Department of Juvenile Justice. This legislation adds those individuals as voting members of the post council to represent the law enforcement officers in which serve under their capacity.
You got about 22 questions.
I had a feeling that was going to be the case.
Which ones you want first? You gave friends in here? No,
I hope I have a lot of friends in here, Mr. Chairman.
I'm sorry, Jay Roberts doesn't work here anymore.
No, he, yeah. Yep. My House floor leader left, and I don't have a House member to be the floor leader for in the Senate anymore.
Yeah, there's not much in the Senate anyway, so don't worry about it. You got no questions.
Thank you, Mr. Chairman. We appreciate your consideration.
Mr. Stone.
Good morning, Mr. Chairman, committee members. Just have one bill today that's on second page under modified structured rule. It is the fifth bill from the top, SB 262. Brought to us by our friends in the judiciary, the justices. This would shorten or reduce change the disqualification degrees of kinship for a judge in a case. Currently, judges cannot overhear cases up to the 6th degree of kinship. Now that is so far out, it gets into second and third cousins that is unworkable, particularly in rural areas. So what they've done in this bill is shorten it.
And how many of you people are in a rural area?
You can't say anything bad about anybody in Burke County because they're probably related. But it lines up the disqualification limits with the same limits that are in effect for the Model Judicial Code of Ethics. And I would urge your favorable consideration.
Mr. Willard.
Thank you, Senator. Good morning.
Yes.
Is it not true this is the same bill that came through by Representative Beskin last year from the House?
It is.
Went to the Senate, didn't get passed. Now it's coming from the Senate as a new bill here.
Exactly.
So y'all aren't having any original ideas over there. You're taking out.
Well, we rely heavily on any source for ideas.
Okay, all right. No other questions. Thank you.
Thank you very much.
Mr. Corbett. And see, Mr. Corbett has already moved over to the Senate.
That would be a demotion, I think. Thank you, Mr. Chairman, members of the committee. Second page, second one down, Senate Bill 184. This bill was introduced last year by Senator Black. I'm presenting it today because his translator was not available to come this morning.
You know I can't get on to you when you tell the truth.
Yeah,
so.
Always. The bill he introduced last year was a bill that had to do with banning breed-specific dogs. All of that language was stripped out. And basically what this bill does, it allows if a dog is AKC registered or UKC registered and sporting breed group dog, hound breed group dog, or non-sporting breed group dog, which takes care of the show dogs and other animals that would be registered that we had in question this morning. It allows them to be able to keep those dogs without having to pay an annual permit or being forced to spay or neuter those dogs. And that's basically all this bill does. And I'd appreciate your favorable consideration.
I don't know what the bill looks like in your book, if it's even in there. Okay, just
I went by legislature.
He came by this morning to do the thing, so it didn't make it. I told him to go ahead and present it. There would be no action until you've seen it sometime today. And again, Mr. Willard.
I've already got one. Not on this bill, but another one.
No, wait a second. Mr. Knight. Tell me about that bill.
What this is doing is keeping our breeders and our dogs, our responsible pet owners who are holding dogs and are doing the right thing from having to pay a higher fee, if you will, to keep a dog intact versus having it spayed and neutered. And what you're seeing around is a effort at the local level to do a mandatory spay and neuter all the way across. What this bill is doing is saying, look, we've got folks out there, responsible pet owners. They're using their dogs, either an AKC, they're AKC registered, or they're sporting dogs, hunting dogs, and thus responsible. And they're not going to have to pay a higher fee than somebody else just because they're intact. And that's what this bill does.
No more questions. Thank you.
Thank you.
Mr. Willard.
Mr. Chairman, I want to ask for Senate Resolution 1027, second from the bottom of the page. I don't know what it's about, but it's Senator Mullis's bill. And I'll be visiting with him today, and I want to let him know that we've asked for that bill to come out.
And Mr. Mullis can't come over here and ask for a bill.
He's busy.
As I went over and asked for bills, so he can't come to me, but I have to go to him.
Well, we're trying to help him out. He's got a lot of load over there with bills coming from the House.
He ain't got no bill over there at 9 o'clock in the morning. No questions. Y'all, we got one other bill here, SB 18. At the top of the third down. I need a move to recommit.
So moved.
Do I hear a second? Second. Is anyone opposed to having that one recommitted? It's recommitted. We will give you some notice here in a little while what we're going to do. Thank you. We're done.